Good morning, everyone. Good morning. Everything is okay? Good morning. Okay, so I will start the last point of our courses concerning the European Union law, European Union integration within the concerns of bioethics. And I will send my courses to Sylvia Kuharuk, and she will resend you again. So, do you have any questions about? Do you have any questions? Any remarks about the topics we saw together? Everything is okay?
I wanted to ask about the exam. Will it be and how it will be?
Do you hear me?
No.
No, now it's okay. Everything is okay.
Yes, I wanted to
Yes.
ask about the exam.
The exam, I don't know exactly. It will be, I will discuss with Sylvia Kuharuk, okay? I will discuss together with her in order to define together a strategy for the exam, okay? I don't know yet. I haven't talked about with her. So I think that she will keep in touch with me, and then I think it will be the best way. Everything is okay. Do you have any questions about the topics we talk about? Everything is okay?
Yeah.
Yes. Yes.
So you will send us the presentations, yes?
Yes. But together I will finish my courses. I don't think that I will be able to continue until 11 o'clock. I will try to give you the most information, and then I will send you my courses, okay? Because the topics I prepared, it's the final topics, okay? Everything is okay in this order?
Yes, but like
Yes.
your voice is coming and going. I don't know, maybe
I
for me.
don't know why. I have a good connection here because I'm not in my office, and at my home I have a very good connection, internet connection. I don't know why it's so complicated to have a so. Okay, so the last I was talk about I was talk about the last time it was okay. Do we have to take about this genetics? On which topic could you recall me, please? The last topic I talked about last week. I have some doubt. Okay. So the last topic will be the exercising economic activity within the European Union and bioethics. The opening up the internal market. In this order, I will shut down my camera. It will be better maybe for you to listen me. Okay? Maybe it's the problem. Okay. So, the opening up of the internal market to body parts and medical services, including reproductive ones, allows them to move from one country to another. This free movement takes place via medical professionals, private individuals for targeted scientific use, or as part of medical treatment. In an exponential way, it widens the possibilities of their use and can lead to their being subjected to the logic of the market. In this context, the bioethical issues have essentially been revealed by the free circulation that encourages economic activity. On this point, the European Union legislation is very explicit. Article 3, paragraph 2 of the Charter of Fundamental Rights is a strong reminder of the prohibition, in principle, on the economic exploitation of the human body and its parts. Affirmed in principle by all the text of European Union law, this prohibition limits the exercise of economic activity and conditions the donation of human body parts and products within the European Union. First of all, the prohibition in principle of deriving economic benefit from the human body and its parts are limits on the exercise of economic activity. The questions of the non-commercialization of the human body as a limit on economic activity has mainly arisen in connection with scientific research involving the human body and its commercial exploitation, and the freedom to provide services involving the human body and its parts. Commercial exploitation of scientific research on the human body. The importance of the debates on the commercial exploitation of scientific research involving the commercialization of the human body become apparent during the drafting of the Directive 98/44 on the legal protection of biotechnological inventions by means of a patent system. The introduction of the European patent system comes at a time when there is a political desire to improve competitiveness within the internal market. In its white paper on completing the internal market, the Commission highlighted the need for the community to have a patent system in the field of biotechnology. For the European Group on Ethics, I'm quoting, patent law is one of the stimulants of medical research, as it allows compensation for research efforts whose progress, both diagnostic and therapeutic, benefits patients, in particular those suffering from genetic diseases. The purpose of patent is to grant a monopoly on the economic exploitation of an invention based on elements of the human body. It is an industrial property right over an invention. The aim of the patent system is to ensure a compromise between the particular interest of the inventor and the general interest of the community. On the one hand, the patent system is to ensure compromise between the particular interest of the inventor and the general interest of the community. On the one hand, the patent aims to protect the invention and defend and defend and defend and and defend the inventor's rights. The states offer the inventor temporary exclusivity of the right to exploit his invention, thereby protecting him from counterfeiting and technical plunder. And technical plunder. On the one hand, the patent aims to protect the invention and defend the inventor's rights. The states offer the inventor temporary exclusivity of the right to exploit his invention, thereby protecting him from counterfeiting and technical plunder. In return, the inventor must provide a precise description of his invention. This disclosure constitutes a contribution to the body of existing technical knowledge and enriches the state of the art. Thus, in the general interest of the community, the patent system, by avoiding secrecy, does not block knowledge but guarantees the freedom of research, and there is freedom of researchers to exchange information. While the protection of biotechnological invention is of great interest for the competitiveness of European scientific research, they undoubtedly raise ethical issues concerning the patentability of living organisms. It is not surprising, therefore, that the initial version of the Commission's proposal for a directive gave rise to a lively debate in the European Parliament, particularly on the subject of banning certain patentable processes relating to the human body. In its resolution on the ethical and legal problems of genetic manipulation, the European Parliament had already taken open stand on the importance of protecting the individual and his or her body with regard to scientific research. Similarly, in its 1996 resolution on the protection of human rights and dignity of the human being with regard to the application of biology and medicine, it expressly stressed that no living human organ or tissue shall be bought, sold, or otherwise treated as a marketable commodity. The final text of Directive 198/44 seeks to reconcile the importance of economically stimulating scientific research and protecting it by means of a patent with the ethical principles inherent in the human body. Article 3, paragraph 1 of the directive specifies its extended scope: new invention involving an inventive step and capable of industrial application shall be patentable, even where they relate to a product composed of or containing biological materials, or to protect for the production, treatment, or use of biological material. Similarly, paragraph 2 of this article extended to any biological material isolated from its natural environment or produced by means of a technical process, because it may be the subject of an invention, even when it pre-exists in its natural state. This broad scope is counterbalanced by the limits imposed of patentability. On this point, the directive seems clear, as it embodies all the positions taken by the European Union institutions right from its recitals. Recital 16 stressed That patent law must be exercised in compliance with the fundamental principle guaranteed human dignity and integrity, and that principle should be reaffirmed that the human body, at the very stage of its formation and development, including germ cells and the simple discovery of one of its elements of project, including the sequence of partial sequence of human gene, are not patentable. Recital 23 states that a simple DNA sequence without any indication of a function does not contain any technical information and cannot therefore be considered a patentable invention. Article 5 of the final text of the final text of the directive final text states that the human body the human body at the various stages of its formation and development, and the mere discovery of one of its elements, including the sequence of partial sequence of a gene, shall not constitute patentable inventions. An element isolated from the human body or otherwise produced by technical process, including the sequence or partial sequence of a gene, may constitute a patentable invention even if the structure of that element is identical to that of a natural element. Article 6 of the same directive states that inventions, the commercial exploitation of which will be contrary to public order or morality, shall be excluded from patentability. In particular, processes for cloning human beings, modification of the germ, line, genetic identity of human beings, the use of human embryos for industrial or commercial purposes, or processes affecting the genetic identity of animals which are likely to cause them sufferings without any substantial medical benefit for humans, and animals may not be patented. The directive establishes a boundary between man and other forms of life by devoting a specific provision to the patentability of the human body and its parts. It also sets out 3 examples of inventions that are excluded from patentability on the grounds that they are contrary to public policy: the cloning of human beings, genetic modification, and the use of human embryos. The provisions of the directive have been incorporated into the implementing regulation to the Convention of the Grant of the European Patents in such a way that their effective application can be guaranteed by the European Patent Office, even though only 4% of patent applications fall within the scope of these provisions. However, although the limits imposed on patentability appear clear at first sight, the system remains ambiguous. The generality of the terms used make it possible to define precisely which elements of the human body of the human body are excluded from patentability, and which inventions, if they relate to the human body, the commercial exploitation of which is contrary to public order and morality. While paragraph 1 of Article 5 excluded the human body from patentability in principle, paragraph 2 authorizes While paragraph 1 of Article 5 excludes the human body from patentability in principle, paragraph 2 authorizes the commercial exploitation of an invention relating to an isolated element of the human body throughout patent protection. This paragraph calls into question the ethical principle of non-commercialization of the human body because it makes the distinction between discovery and invention applicable to the human body and its isolated elements. However, the distinction between discovery and invention is not the easiest to establish when it comes to elements of the human body. Is it conceivable that a human gene isolated from the human body is an invention and can therefore be commercially exploited under patent protection? Does the concept of invention apply to the isolated gene or to technical process used to isolate the gene? Under the directive, the line between invention and discovery is blurred because it does not specify the concrete criteria for making this distinction operational when applied to the human genome. Far from being a hypothetical question, that this issue has already been raised in the context of medical research on DNA and its economic exploitation. The question was whether the process used on human DNA was a discovery or an invention within the meaning of Article 5 of the directive. To answer this question, it was necessary to determine whether the human genome, representing the sum of genetic information and as an essential element of the human body, could give rise to technical inventions. This point is not expressly settled in a clear and precise manner in the directive. The prima facie approach is to consider the human body as a single global entity and consequently to exclude any patentability of the human genome, which would in principle also be contrary to the good morals referred to in Article 6 of the directive. In its decision of 16 July 1997, the European Patent Office stated that the human body, at the various stages of its formation and development, as well as the mere discovery of one of these elements, including the sequence of partial sequence of a gene, cannot constitute patentable inventions. In a 1904 decision, the same office held that DNA is not life, but a substance carrying genetic information, and that a patent on a single human gene and patent of human life are two quite distinct things. Consequently, isolating characteristic and DNA fragment coding for a human protein does not constitute a discovery, but an invention. Finally, there is nothing morally wrong with such a human invention. The directive endorses the position of the European Patent Office. Its main objective remains the guarantee of the competitiveness of the undertaken within the European Union. Ethical principles are thus relegated to the background. This situation was also highlighted by the Commission in its report on the application of the directive. Indeed, in point 2.1 on the report, the Commission highlighted this difficulty with regard to patents on the sequence of a gene. It states that according to Article 5, paragraph 3 and recital 23, at 25, the community legislator intended at least to consider the possibility of limited protection covering only the specific industrial application, identified the patent to the extent that this particular type of invention is concerned. Otherwise, Article 5, paragraph 3, which requires that the industrial application of a gene sequence be concretely disclosed in the patent application, merely repeats the standard requirements of general patent law, as shown in recital 22. The directive endorses the position of the European Patent Office. Its main objective remains to guarantee the competitiveness of companies within the European Union. Ethical principles appears to be relegated to second place. This situation was also highlighted by the Commission in its report of the application of the directive. In point 2.1 of the report, the Commission highlighted this difficulty in relation to patents, often the sequence of a gene. The informal expert group met in March 2003 to discuss this issue. A majority of members felt that there were no objective reasons for creating a specific regime on function-based protection in this area, which differs from conventional patent protection. In particular, the technical and legal experts felt that there were no differences between DNA sequences and chemicals that would justify a different treatment with respect to the extent of protection conferred by a patent. The European Parliament, for its part, asked the European Patent Office and the Member States to grant patents on human DNA only when they are limited to a concrete application. Demand also that the scope of the patent be limited to the specific application, and so that other users can use and patent the same DNA sequence for other applications. Function-based protection. Similarly, the Parliament also invited the Commission to examine whether this interpretation of the directive could be obtained in the form of a recommendation to the Member States, or whether it is necessary to amend Article 5 of the directive for that purpose. It also justifies its position by the principal postulate that no consideration in research can take precedence over human dignity. The ambiguity of Article 5 of the directive was strongly criticized. The doctrine even considers that paragraph 2 contradicts paragraph 1 by emptying of its meaning and sowing confusion between the notions of discovery and invention. According to other authors, there is a risk of commercial drift if any element of the human body is patentable once it is isolated from it. These authors express concerns about the confiscation of genetic knowledge. Genes are likely to be multifunctional. Granting a monopoly on the exploitation of this gene before all their properties and their potential field of use have been identified is dangerous for society and medical research, as the grant of the patent could freeze other innovation. This explains This explains to some extent the controversial nature of the directive, not only by the European Parliament, but also by some member states. These criticisms are likely to be amplified by the position of the US Supreme Court. Indeed, the Supreme Court, in its Miriam genetic judgment, referred to its original position allowing DNA sequences to be patented. Now, for the court, DNA is a project of nature and therefore not patentable. Directive 20A-44 has not yet been amended on this point, although this criticism can be understood by the literal reading of the directive and its application by the European Patent Office. They must nevertheless be qualified. Indeed, as the Commission points out, Article 5 of the directive must be interpreted with the general framework of the directive itself and the protection it provides. The directive thus imposes additional requirements, particularly when it comes to examining a patent application. The classic conditions of patentability apply fully: novelty, inventive step, and industrial application. The industrial application of sequence of partial sequence must be set out in concrete terms in the patent application as field, and for the criterion of industrial application to be met. It is necessary in the case where a sequence or partial sequence of gene is used for the production of a protein or partial protein to specify which protein or partial protein is produced or what function it performs. Its purpose. In the operative part of Article 3 of Article 5 also add to this, and conferring a concrete utility to that function industrial application. Thus, in view of the controversy raised by the directive when it concerns human living or biological matter, it is for the European Patent Office and the Court of Justice to further clarify the scope both with regard to patentable biological material and invention prohibited under Article 5 and 6 of the directive. Initially, the Court of Justice used the classical technique of complying with the requirements of the directive when it was transposed by the Member States. In its judgment in Commission versus Italy, the Court recalled the special nature of Article 5, paragraph 2 of the directive because it seeks to grant specific rights with regard to the patentability of elements of the human body. In that regards, even if that provision provides for a simple possibility of patenting, it imposes on the Member States, as is apparent from recital 17 to 20 of the directive, the obligation to provide that their national patent law does not exclude the patentability of isolated elements of the human body, in order to encourage research aimed at obtaining and isolating such valuable elements for the production of medicines. Similarly, as regards Article 6 of the directive, the Court recalls that under Article 6, paragraph 2 of the directive, processes for cloning human beings, processes for modifying the germ-line genetic identity of human beings are not patentable. The use of human embryos for industrial or commercial purposes, processes to modify the genetic identity of animals in such a way as to cause suffering without substantial medical utility for humans or animals, and animals resulting from such processes. It should be noted that contrary to Article 6, paragraph 1 of this directive, which leaves the administrative authorities and courts of the Member States a wide margin of discretion in applying the exclusion from patentability to inventions whose commercial exploitation will be contrary to public policy and public morality. Paragraph 2 of the same article leaves no margin for discretion to Member States as regards the not patentability of the processes and uses listed therein. This provision being intended precisely to frame the exclusion provided for in paragraph 1. In this respect, it is clear from the 40th recital in the preamble to the directive that the patentability of processes for cloning human beings must be included univocally, since there is a consensus on this issue within the community. It follows that by explicitly excluding the patentability of the processes and the use referred to therein, Article 6, paragraph 1 of the directive seeks to grant specific rights on this point. These provisions oblige states to transpose it expressly. Secondly, in the Brussels judgment, the Court of Justice used the method of autonomous interpretation to define the concept of embryo under Article 6 of Directive 19/844. This method is chosen by the judge when he is faced with the problem of uniform application for a given regulation, In that judgment, the court first found that the directive makes no reference to the rights of member states for the definition of that concept. It concluded that only an autonomous interpretation was possible, the concept of embryo being to be considered as a concept of European Union law, which is independent in view of the objectives of the directive. Secondly, having regard to the primary objective on the directive and to the place of human dignity and the European Union law, the Court of Justice held that only a broad interpretation of this concept could remedy the conceptual differences between the embryos in the member states and not merely allow to directive to be effective, but also the protection of the human dignity and the human body. Although this method, this method Although this method does help to remove the ambiguity of the terms used in the directive, it has quickly shown in its limits. Indeed, in the International Sperm Cells judgment, the Court of Justice has reverted to this bold approach. In that judgment, it favored a casuistic assessment of the unfertilized ovum to be handled in order to determine whether or not it can, by being technically stimulated, develop into a human being. This confirms once again that the solution of case law can only be temporary and cannot replace, in a union governed by the rule of law, the union's legislator. While it can fill gaps in the text, it cannot broaden its scope. The solution remains limited to the specific facts of each species and leads to an in situ and in concreto approach to Article 5 and 6 of the directive. While such an approach is undoubtedly of interest, it shows its limits, in particular by the questionable solution to which it can lead in absence of conceptual clarification of the principle of non-commercialization of the human body. The comparison of this principle with the freedom to provide services is a perfect illustration of this situation. I finished my purposes for today and my courses and with the topics concerning the European law in on bioethics, and I will check with Sylvia what about the exam, and I will send you. Maybe I will send